Okay, welcome to Lecture 2 for Topic 8, and in this we're going to look at prior restraint in the press. So as I mentioned in the last lecture, the textbook covers three areas regarding regarding the Supreme Court and press freedoms. They cover prior restraint, government control of press content, and the special rights of reporters. As your textbook points out, these three make up the core of the freedom of the press in the United States. In this lecture, we're going to focus just on prior restraint, and I will leave it up to you to read about government control of press content and the special rights of reporters. So let's get started on prior restraint. So what is prior restraint? Well, prior restraint is defined as that when government reviews material to determine whether publication of the material should be allowed. And so basically it's placing a restraint on what can be published prior to the newspaper or magazine actually going to press and being published. So in a way, it's like the government is looking over the shoulder of print media, or it could be really any kind of media, but reviewing it and saying, yes, you can publish it. No, you cannot publish it. So when you think about prior restraint, it's really just government censorship of the press because they're reviewing it before it goes to publication. And it's really considered just contrary, or as your textbook puts it, antithetical to freedom of the press. Countries that have where the government has the ability to look at what's going to be published before it goes to publication those are countries that are considered not to have a free press. And from your textbook's perspective, and I think most civil libertarians and others democratic theorists agree, that no concept is more important to understanding the freedom of the press than prior restraint. So your textbook dedicates three cases to getting so that you can understand how the Supreme Court has created a doctrine on prior restraint. And that's what we're going to look at. And so we're going to take a look at the three cases: Neer versus Minnesota, New York Times versus the United States, and Hazelwood School District versus Kohlmeyer. These are the three cases that your textbook talks about regarding prior restraint, and these are really sort of the most important cases as it relates to understanding the doctrine and the approach that the Supreme Court has taken to prior restraint. So let's get started. Okay, so let's talk about the facts of the case of Neer versus Minnesota. Neer versus Minnesota is about a Minnesota law and a press, a newspaper called the Saturday Press. And as we'll read about in your textbook, the Saturday Press was just basically like kind of a racist, anti-Semitic publication that said it was dedicated to uncovering corruption in Minneapolis, but you'll see in the textbook, I mean, in their efforts to uncover corruption, they're completely racist and completely anti-Semitic, and they're saying things that aren't necessarily founded in evidence. They're just basically sort of this hideous publication that's sort of posing as this deep investigative news journalism. And people were sort of angry about the existence of the Saturday Press. And so there was a law on the books in Minnesota that basically provided for the abatement or removal as a public nuisance of any malicious, scandalous, and defamatory paper, magazine, or other periodical. And people looked at the Saturday Press and they were like, that kind of fits the bill, right? It is a scandalous, malicious, defamatory publication. And so in 1927, a county attorney asked a state judge to issue a restraining order barring the publication of the Saturday Press. Because in the view of the attorney, because it was seen as being this sort of hideous newspaper that should be not able to be published. From the viewpoint of the people who owned the newspaper, J. Neer was one of those individuals. They basically thought that this restraining order that was prohibiting them from the sale to printing their newspaper and selling it. It also restrained future editions of the newspaper. They basically said that was a violation of the First Amendment's freedom of speech. The picture there is of the man. He's the editor. His name's Colonel Robert McCormick. He's the editor and the publisher of the Chicago Tribune. So initially, the ACLU was going to defend Jay Neer in this case, but then they dropped Jay Neer, and that the editor of the Chicago Tribune took up the case. And so that's the backstory or the facts of the case for Neer versus Minnesota. So the question before the court in Neer versus Minnesota is a statute authorizing the prior restraint of a newspaper consistent with the liberty of the freedom of the press? And in a 5-4 vote, the Supreme Court found that the Minnesota statute was unconstitutional. Why did they rule in that way? Well, they said that government cannot censor a publication in advance in most situations, okay? That it is that the government giving the government the power of prior restraint just basically makes press freedom meaningless. And so what the court said is that the publication can go to print, okay, and then they can be subject to criminal and libel law after publication, but the government can't have the power to restrain the publication restrain the newspaper prior to it going to publication. They keep the door open to say that prior restraint could be exercised in some very limited circumstances. And they basically said that when what's being published jeopardizes national security, or if what's being published could incite violence, then perhaps the government could step in and exercise prior restraint. But in this instance, where you just have this malicious, racist, anti-Semitic kind of diatribe of a newspaper, the government does not have the power to restrain that publication prior to it actually going to print. So Neer versus Minnesota is an important case for a variety of reasons. One reason that case is important is because it incorporates the freedom of the press to the states. You'll notice this was about an effort of a state to exercise prior restraint. And so Neer versus Minnesota incorporates that provision of the First Amendment to the states. It's also an important case because it basically sort of sets the ground, like basically saying government cannot engage in prior restraint. The only time it could engage in prior restraint is in some very limited circumstances. And one of those limited circumstances was if national security is at threat. And so, like I said in the last slide, that the door's just open a little bit, not a lot, but the door is opened a little bit that still would provide the government the power to engage in prior restraint. And that's the question that comes up in the landmark case, New York Times versus the United States. It's a case that deals with prior restraint on national security issues. So the question, is can the government exercise prior restraint on national security matters? Could a government prevent a newspaper from publishing classified information that might jeopardize the safety of military members, right? So let's say that a newspaper, got some coordinates of troop movements during a war and that they wanted the public to be fully informed about that war. Could they publish those in the name of informing the public, even though they might be jeopardizing the safety of the troops? So could government step in and prevent newspapers from publishing that kind of information? Or does the government have to wait until after the publication to issue those charges? So again, is the Supreme Court going to say really hardcore, no prior restraint, even if it's jeopardizing national security, that we have to wait for the publication and then, charge the publication, which in and of itself might be enough to, have a publication think twice about publishing information. You think about the WikiLeaks drops and the New York Times decision to print some of the classified or information or private information from the State Department to print that in the name of sort of informing the public. They thought long and hard about whether or not they should do that, and they retracted information that they did feel would threaten national security. So, even if you said you could publish it, but you could be criminally prosecuted, that actually might be enough to restrain the news media. But the broader question is, could the government do it if they wanted to? And that's the question that comes to the court in the case New York Times versus United States. So let's look at the facts of that case. So let's look at the facts of the case in New York Times versus the United States. So this is a case about a Defense Department employee. His name's Daniel Ellsberg, and that he had access to this classified information from the government about the war in Vietnam. One of the documents had to do with the Gulf of Tonkin incident, and the other was a very long report that was produced by the Defense Department called The History of U.S. Decision-Making Process on Vietnam Policy. And as I had mentioned earlier, the piece on the history of the policymaking basically showed that the United States government knew that they couldn't win the war in Vietnam, yet they kept sending troops over there, even though they knew it was a losing battle. So when Daniel Ellsberg saw this information, he felt like he had a duty to basically leak this information to the newspaper in order to inform people about the failed policy in Vietnam. And so he copied portions of these two reports, and then he on the slide took them out of the office where he was working, and then he turned them over to the Washington Post and the New York Times for publication because he felt that it was important that people were informed. Well, after the New York Times and the Washington Post had published several installments of the Pentagon paper, the United States government basically took action. And they basically asked a district court to restrain the newspapers from publishing any more of the information from the so-called Pentagon papers. And the government's argument was that these articles would really cause irreparable damage and harm to the national security of the United States. And so, the question is, and in fact, the New York Times and the Washington Post, that there was a restraining order that was put in place, and that the question was whether or not the U.S. government had the power to do that, and whether or not that if the New York Times and the Washington Post kept publishing them, whether they would be in a lot of trouble because they were violating these court orders. So let's look at the question that was before the court. So the question before the court in the New York Times versus the United States is, does the government interest in protecting national security justify prior restraint, right? So it's kind of questioning that door that's left partially open in Neer versus Minnesota. And in a 6-3 vote, the Supreme Court said no, that national security does not justify prior restraint. Make sure you read about how quickly this case was heard by the Supreme Court. Also, there's lots of different opinions to read in the textbook, so I encourage you to read them. We're just doing a quick overview of that because all the justices wanted to weigh in on this very important issue. They basically said any system of prior restraint comes to the court bearing a heavy presumption against constitutional validity. And so basically they're assuming that government's efforts to prior restrain publication is unconstitutional, and that the government needs to make a really, really strong case for why this prior restraint is needed. And the government wasn't able to make that case in the New York Times case. They said that here the government does not meet the heavy burden of showing justification for the imposition of such a prior restraint. They basically said that there was no evidence that printing these excerpts of the Pentagon papers, that it was that they said it was basically historical in nature, and there was no evidence that it would actually impact or jeopardize the national security of the United States. Now, the door is still slightly opened after this case because they're saying in this instance it didn't rise to the level of violating national security, but maybe in the future, maybe it would, right? So it's not like prior restraint is completely taken off the table, like that government cannot do it. They just can't do it in this case, and this case doesn't rise to the level of jeopardizing national security, but maybe a case in the future would. So let's switch gears to take a look at prior restraint as it applies to student newspapers. I wanted to say on that last slide where it had the picture of all those lawyerly looking people in front of the Supreme Court, those were actually all the lawyers who defended the New York Times. And so if you're wondering, who are those people? That's who those people were. So from the previous cases, we know that students, when it comes to students' rights, from Tinker versus Des Moines and Frederick v. Morse, we know that students do not lose their right to freedom of speech when they enter into the public school. In the Tinker case, the court was very clear about that. You don't check your First Amendment rights at the door. The cases that we read up to this point in class deal with speech, but what about press? Do students check their freedom of press rights at the door when they enter into the school? Now, keep in mind that in both Tinker v. Des Moines and in the Morse Frederick, the Bong Hits for Jesus case, keep in mind that that students' rights are not as robust as, particularly when they're in school, they're not as robust as they would be outside of school in a public environment, outside of the school grounds, because the interest of the state is heightened in the school, right? The state has an interest to make sure that that the learning environment is maintained, that students are protected, and that the speech actions of students wouldn't result in some harm or disorder for the other students going to school. And so what about freedom of the press? Does the prohibition against prior restraint extend to student newspapers? Or can school administrators review and remove articles prior to publication, prior restraint? And so we get the answer to that question in the last case we're going to discuss. So let's take a look at that. So let's look at the facts of the case in Hazelwood School District versus Kohlmeyer. And that's a picture of Kathy Kohlmeyer. She is one of the editors for the school newspaper, which is called The Spectrum, which was in Missouri. And this case revolves around that school newspaper. So the Spectrum, as you read in your textbook, the Spectrum, it's a high school newspaper, and they plan to publish articles about teen pregnancy and divorce. And in fact, they have an excerpt from the article in the textbook that you can take a look at. The school principal said, look, so the school looked at the articles that were going to be published about these sensitive topics, and they said that the way that these articles were written, that the readers could figure out who the students were, and there's sort of sensitive information about divorce and teen pregnancy, and there weren't a lot of pregnant teens in school. So I mean, you're writing an article about teen pregnancy, and everybody sort of like knows maybe who those people are. And so the principal said that he would not allow these articles to be published. And so he removed those articles and other material from the newspaper prior to publication. And the school staff challenged the ruling, and they said that this was prior restraint, that this was censorship. And so Kathy Kohlmeyer and some of the other students hired a lawyer, and they wanted to challenge the decision that the school made in court, basically saying that the school exercised prior restraint on their newspaper and that the First Amendment protects the students and the student newspaper from prior restraint. So let's look at how the court ruled in this case. So what was the question before the court in the Hazelwood case? The question before the court is, well, may educators exercise editorial control over the content of a high school publication produced as a part of the school journalism curriculum? In other words, can high school administrators exercise prior restraint, restraining the content of the paper before it goes to press? And in a 5-3 vote, the Supreme Court said that yes, that the school can exercise prior restraint, at least in certain circumstances. They basically said that the school newspaper was a part of the school curriculum, that students signed up for the class that did the school newspaper, and that the school then, because it's a part of the school curriculum, the school has authority over what that curriculum will be. And if the school decides that that curriculum is not going to cover these sensitive topics, then the school can decide that they want to alter the curriculum. School administrators have control over curriculum. They also said that educators are entitled to exercise greater control over such activities to make sure that the students learn the lesson that is being taught to them. And that the lesson that's being taught to them here was that they felt that the article in the newspaper was one-sided, that there were interviews with students about their parents in divorce, but they didn't give the parents the opportunities to be interviewed and tell their side of the story. And so they basically said that what we are teaching you is how to be good reporters, and good reporters will report on both sides of the story. And good reporters will also, if negative comments are made about somebody, good reporters give an opportunity to the person that is the subject of those negative comments to make a comment and to defend themselves. So they basically said that that in a way wasn't even maybe prior restraint, but that basically they had a particular curriculum, and the way that the articles were being written were sort of outside or in offense to the curriculum that was being taught. So in these, that doesn't mean that school administrators could willy-nilly prior restraint. There has to be some reasons for that prior restraint, and we get a sense of what those reasons are in this case. Okay, that's just a quick overview of those 3 cases. There's other cases to read. It's a really interesting chapter. So I look forward to your future writings on this material because it's quite an interesting topic. Okay, thanks for listening. Talk to you again soon.